So welcome to Privacy Considerations for Ontario Private Corporations. My name is Alysia Christiaen, and I'm a corporate lawyer at Learners. A specialty in my practice is privacy law. Today's presentation is for informational purposes only and is not meant to be legal advice. So thank you very much for joining us. I'll launch right in. Privacy compliance is often seen as a necessary evil in a business, something that has to be done because there are laws in place that a business has to comply with to avoid getting a fine or being the subject of an investigation by the Office of the Privacy Commissioner of Canada. But having a culture of trust in your organization adds value to your business. As you will learn, customers are loyal to companies that protect their information. So in today's presentation, we're going to be touching on privacy legislation. We'll be talking about your privacy management program, personal information, some employee privacy issues, and then we'll finish off with some practical tips. So part of being an accountable organization, accountable to your customers, to your employees, and to your regulator, is having a privacy management program in place. When resources are so limited, why would a business want to spend the time and money on a privacy management program? Well, the easy answer is that you have to. It's a statutory requirement under applicable privacy legislation. The more nuanced answer is that it will benefit your business. A robust privacy management program fosters a culture of trust within your organization. Internally, your staff will know that you respect their privacy and handle their personal information appropriately. And your clients are expecting you to protect the personal information that they share with your business. GetApp conducted an online consumer privacy survey in the summer of 2022. It surveyed over 1,000 adult Canadian consumers who shopped online at least once a month. The results were clear. Consumers expect businesses to protect their personal information, and their decision to transact with a business is influenced by its data protection practices. Some interesting findings from the GetApp survey that businesses should pay attention to include that 33% of the respondents said that they are more concerned about the data privacy practices of companies compared to a year ago. 79% of those surveyed indicated that they factor a company's data privacy practices into their decision about whether to do business with it. And 19% of consumers always researched a company's data privacy reputation before transacting with it. Failing to have a fulsome privacy management program in place could cost a business sales and a loss of client confidence. So currently all Ontario private corporations are required to comply with the Personal Information Protection and Electronic Documents Act. If you're in the healthcare field, you are required to comply with the Personal Health Information Protection Act. Today's presentation will focus more on PIPEDA, but the principles apply equally to P-HIPAA compliant organizations. PIPEDA has been in force since 2001, so over 20 years, without any significant revisions. This is pretty remarkable when you think about how fast technology changes, the explosive adoption of artificial intelligence, and how much personal information we now share with companies as we move further into the digital age. The federal government has recognized the need to modernize Canadian privacy laws and has tabled Bill C-27, the Digital Charter Implementation Act. This bill, if passed, will enact 3 pieces of legislation: the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. The CPP will replace the privacy protection provisions of PIPEDA and will move Canada more in line with international privacy protection regimes. Both PIPEDA and the CPPA make specific reference to the requirements of a privacy management program. Every organization must implement and maintain a program that includes the policies, practices, and procedures that it has in place to fulfill its obligations under PIPEDA and eventually CPPA, including those respecting the protection of personal information, how requests for information and complaints are received and dealt with, the training and information provided to the organization's staff respecting its policies, practices, and procedures, and the development of materials to explain the organization's policies and procedures. In developing the privacy management program, a company has to take into account the volume and the sensitivity of the personal information that it controls. New to the CPPA is an enforcement clause for the Privacy Commissioner. On request, an organization must provide the Commissioner with access to the policies, practices, and procedures that it has in its privacy management program. The Commissioner is able to recommend that a business take corrective measures in relation to their program. Many businesses have put privacy and data protection on the bottom of the list in terms of operational priorities. When the CPPA is enacted, and there's nothing to suggest that it won't be, businesses who have ignored their privacy obligations in the past will be scrambling to bring themselves into compliance. And failure to do so can be met with significant penalties under the CPPA. Organizations of an indictable offense are liable to a fine of up to 5% of their global revenue, or $25 million, whichever is greater. There are also administrative monetary penalties of up to 3% of global revenue, or $10 million for select violations of the CPPA. The administrative monetary penalties apply to contraventions by a business related to establishment and implementation of a privacy management program, failure to ensure equivalent protection for personal information transferred to a service provider, failure to set out specific obligations for service providers, and transparency failures with their clients. To provide some relief to the anxiety that may have arisen with the knowledge of these monetary fines and penalties, PIPEDA also has them, and they've never once been applied. However, it does seem that the federal government is moving in the direction of more stringent data protection, so the fines and penalties under the CPPA may not be empty threats like they are currently. Certainly, the data protection authorities in the European Union have absolutely no problem levying very significant fines against violators of their data protection legislation. And the Canadian government is, with the CPPA, trying to move us closer to the EU standard. The size of your business does not matter. Whether you have one customer or 100 customers or thousands of customers, you need to have a privacy management program in place. Your program should reflect the sensitivity of the data that your business handles. The more sensitive it is, the more comprehensive the program and your safeguards should be. If your company was responsible for transporting large sums of money to banks, you aren't going to use your family SUV, you're going to use your Brinks truck. The same applies to the sensitivity of the data that you manage. The more sensitive, the stronger the safeguards. So what do you need when building your privacy management program? An organization is responsible for personal information under its control. It must designate an individual that is responsible for the organization's compliance with PIPEDA. This person is typically the company's privacy officer. The name of the privacy officer has to be disclosed on request, and a means of reaching them is often set out in the corporation's publicly available privacy policy. The key policies that a business needs to have as part of its privacy management program are the following: collection, use, and disclosure of personal information, including requirements for consent and notification if there is disclosure, retention and disposal of personal information, responsible use of information, including administrative, physical, and technological controls, and a breach response plan. An organization is expected to have a process in place for responding to an individual's request for access to and correction of their information, and for responding to any complaints received about the business's protection of personal information. Another component of a privacy management program is data protection agreements. These are contracts with third-party vendors or service providers that your business relies on to process the personal information you collect from your customers. These contracts are to ensure that the third party that you've shared information with is providing a comparable level of protection while processing it. A privacy officer has a number of responsibilities. They are accountable for structuring, designing, and managing the program. A privacy officer should also work to ensure that privacy protection is built into every major function involving the use of personal information in your organization. So that includes product development, customer services, marketing. Another important responsibility of a privacy officer is to ensure that sufficient and appropriate resources are allocated for the privacy program implementation. reviewing privacy policies, managing privacy risks, and ensuring periodic assessments are done to see if compliance is met by the organization are all tasks that a privacy officer needs to be doing. Businesses should establish some form of internal audit and assurance program to monitor compliance with their privacy policies. This could include the form of customer and employee feedback for smaller organizations, or for some larger organizations, third-party verifications. These reports will also help should the organization be subject to an investigation or an audit by the Privacy Commissioner, as they're more likely to be able to demonstrate due diligence. It isn't enough to just write a policy or a procedure and post it to your organization's intranet or stick it in your employee handbook. You need to be taking steps to ensure the policy and the procedures are being complied with. The privacy officer is responsible for responding to complaint investigations from the Privacy Commissioner. Having a strong privacy management program is a good defense to many of the complaints brought to the commissioners. A privacy officer also needs to advocate for a culture of data protection within the organization. This is going to be an impossible mission if there's not buy-in from the management level. How does a privacy officer get them on board? The officer needs to be highlighting the importance of data protection and privacy to your customers. Data protection isn't about legislative compliance, it's about building value in your company and customer loyalty to your brand. The narrative needs to be reframed to emphasize the benefits a company reaps if it takes protecting privacy seriously. When we're doing merger and acquisitions here, so a client's purchasing a company, one of the things that we do as part of our due diligence is review the potential company that's being purchased to see what their data protection program is like, what kind of data privacy safeguards they have in place. That's what I mean about increasing the value in your business. More and more, when companies are being purchased, part of due diligence involves making sure that there are appropriate data protection policies and safeguards in place. If you are a company that is lacking in those areas, it can significantly impact the purchase price for your company. Privacy program controls ensure that what is mandated in the privacy governance structure is implemented in the organization. A personal information inventory sets out the personal information that the business currently holds and how it is handling that personal information. Understanding and documenting the types of personal information that you collect and where it is held are critically important. This will affect the type of consent the business obtains from individuals and how the information is protected, and it will make it easier to assist individuals in exercising access and correction rights. As discussed, organizations are required to develop internal policies that give effect to the principles contained in PIPEDA. The most common risk assessment tool is the privacy impact assessment, and a second is threat analysis. These should be completed annually. One of the most common types of threat analysis is a vulnerability assessment and penetration testing. So this is when a third party is hired to try to hack into your system, and they identify vulnerabilities that can be taken advantage of to gain access to your network. As the business's operations evolve, so too do its privacy risks. Before a company offers a new service, a new program, or a product that requires personal information to be collected, a privacy impact assessment should be conducted. You want to evaluate the exposure of your client's personal information through this program or a product or service, and make sure that there are appropriate safeguards in place to ensure that it's protected. The most well-developed privacy management program will not succeed if the frontline team, your staff, are not trained on how to implement it. Different positions in the company will have different responsibilities in implementing the program. Training and education needs to be recurrent, and the content of the program needs to be periodically revisited and updated to reflect changes. Human error is the most common cause of reported breaches, resulting in a real risk of significant harm to an individual. Examples include misdirected faxes and emails, email addresses that are viewable in mass emails, inappropriate disposal of documents, and disclosure of passwords. Employees should be required to sign an agreement to comply with your company's privacy policies and program controls. For privacy training and education to be effective, it needs to be mandatory for all new employees before they access personal information and periodically thereafter. It needs to cover the policies and procedures established by your company. It needs to be delivered in the most appropriate and effective manner based on organizational needs. And it needs to circulate essential information to relevant employees as soon as practical if an urgent need arises. So I have a client, and we implemented a training program for their staff. They have approximately about 500 staff. They did their own internal kind of testing of how well-versed their staff were in the privacy protection policies and safeguards that had been covered in the training. Of the phishing attempts that were conducted, there were actually 70 employees that failed. Luckily, it was an internal test and not some hacker trying to get into their system. And that was within 2 weeks of the training. So it really highlights the need to make sure that this training your staff is an ongoing priority. You want to make sure that it's always top of mind, because as indicated, human error is the most common way for a breach to occur. So when there is a data breach incident, you want to be prepared to respond to it immediately. Every organization should have a breach incident plan setting out the procedure to be followed in the event of a breach, who will be responsible for what function, who will be coordinating the response. In these situations, you do not want to be wasting time trying to figure out who is doing what. You want immediate containment. You should also be testing this plan periodically. Most businesses are relying on third parties to collect and or process the personal information of their clients. This is permitted under PIPEDA and the CPPA. However, you don't get to download your privacy obligations onto a third-party service provider. Corporations remain responsible for the privacy protection of all personal information shared with third parties. The easiest way to ensure that a service provider has appropriate security safeguards in place is to have it set out in a contract. That contract is often called a data protection agreement. Before signing a DPA with a third-party service provider, your privacy officer should have completed a full privacy impact and risk assessment on the vendor. Everyone else is using this platform or program or app, so it must be good approach to privacy protection is not acceptable, especially if you were ever audited or under investigation by the Privacy Commissioner. You need to be doing your own due diligence of all service provider. That means reading their privacy policy, reading the service agreement that you signed to engage the vendor, and understanding the privacy protection policies, protocols, and safeguards that vendor has in place before you give it access to your client's personal information. Another consideration to keep in mind when you're engaging a third-party service provider is where is the personal information you provide about your clients going to be stored. If it's outside of Canada, you've now exposed your client's personal information to the laws of a foreign jurisdiction, which will include how that information is handled, which will deal with what kind of access government authorities have to it. This is the root concern that was addressed with the banning of the use of TikTok on federal government devices. At a minimum, you want to ensure that the third-party service provider names a person to handle all privacy matters related to the information that you've transferred to it, that there's limits to its use of the information to the purposes authorized by your organization. The last thing that you want to do is engage a third-party service provider who's going to do whatever they want with the information of your clients once it's in their possession. Your DPA should limit the disclosure of the information by the third party to what's authorized by your organization or required by law. It should refer to your organization any access requests or complaints relating to the information transferred. You want to make sure that the vendor uses appropriate security measures to protect the personal information you transfer to it. There should be clearly set out how the personal information will be returned or disposed of upon completion of the contract. And you want the contract to include reports on the adequacy of the vendor's personal information security and control measures, and allow your organization to audit its compliance as necessary. It's quite hard to get service providers to agree to audits. I actually tell my clients not to agree to them myself. But you do want to have in place some form of assurance that the service provider is living up to the data security safeguards it says it has in place. A common way of doing that is asking to get an executive summary of annual penetration testing that's completed. If they have industry certifications, those typically need to be renewed annually. So asking for the summary that's done by the certifying agency, showing that it remains compliant with certification requirements. Another important component of a robust privacy management program is the external communications that you have with your customers and your clients. The easiest way to do this is with an easy to understand privacy policy that's posted on your company's website. A privacy policy with a bunch of legalese that makes no sense to anyone, but those with a law degree, is not helpful to your clients, and it's actually prohibited under the CPPA. Your privacy policy should provide enough information so that the public knows the purpose of the collection, use, and disclosure of their personal information, as well as how your company safeguards it and how long your company retains that information. It should notify individuals if their personal information is being transferred outside of Canada. It should include information on who to contact with questions or concerns, and should also notify individuals that they have a right to access and correct their personal information and the right to complain about your company's privacy practices, including by submitting a complaint to the applicable privacy commissioner. Once you have your privacy management program in place, there needs to be an ongoing commitment to ensure that it continues to meet the privacy protection obligations of your organization. As your products and services deliver change, or you take on new vendors, or you move to a remote work setting, consideration needs to be given to whether any of your privacy policies and practices needs to be revised. Practically, what does this mean? Do not keep your privacy officer in the dark. Your privacy officer is an integral part of complying with your statutory privacy protection requirements. They need to be involved across all functions of your business: human resources, marketing, research and development, sales. Now, obviously, depending on the size of your business, you may not have a dedicated privacy officer, but there still needs to be someone in your organization who is tasked with being responsible for privacy. There should be an oversight and review plan completed on an annual basis that sets out how compliance with the privacy management program will be assessed, and a schedule for a review of the components of your program. The privacy officer will want to assess each of the privacy program controls and determine if a control needs to be revised or updated. Monitoring is an ongoing process and should address at a minimum the following questions. What are the latest threats and risks? Are the program controls addressing these new threats and reflecting the latest guidance of the Privacy Commissioner? Are new services being offered by your company that involve increased collection, use, or disclosure of personal information? And is training occurring? And is it effective? Are policies and procedures being followed? And is the training program up to date? One thing that should be becoming clear is that privacy management requires a business to invest resources in it if it wants to have a compliant program, compliant with the statutory requirements, but more importantly, compliant with the expectations of your clients and your customers. So what is personal information? PIPEDA defines it as information about an identifiable individual. It is any factual or subjective information, recorded or not, about an identifiable individual. This includes information in any form, such as age, name, ID numbers, income, ethnic origin, blood type, opinions, evaluations, social status, any disciplinary action taken against them, employee files, credit records, loan information, medical records. Information will be about an identifiable individual where there is a serious possibility that an individual could be identified through the use of that information, either alone or in combination with other information. I was once retained by a physician to assist in responding to a complaint that had been brought to the College of Physicians and Surgeons of Ontario against them. The physician was a ENT specialist, ear, nose, and throat specialist, who would often get called down to the emergency department to deal with people who had things stuck in their ear, nose, or throat. He thought it would be funny to post x-rays to his Facebook profile showing odd things that he had to remove from people. One of his Facebook friends did not think it was funny and made the complaint to the college. I was able to have that complaint dismissed really on a technicality because I was able to argue that the x-rays were not identifiable information. So they weren't about an identifiable individual. So now, because it's an x-ray, which is a medical record, you'd think that by default, that is personal information. Because the Facebook friends could not tell who the individual was that was being depicted in the x-ray, I was able to argue that the x-rays were not personal information in that circumstance. Really hinging on the fact that there wasn't a health card number showing, there wasn't the name of the patient showing on the x-ray. So hopefully that example gives you a bit better understanding of the identifiable individual component of personal information. Moral of that story is really don't post stuff about your clients on Facebook. It's not the place to do it. Consent is a cornerstone to all aspects of the collection, use, and disclosure of a person's information. Under PIPEDA, consent is to be informed and knowledgeable, which requires the individual to know and understand the purposes for the collection, use, or disclosure of their personal information. Under the CPPA, consent is to be valid. Practically speaking, there isn't really a difference between informed and knowledgeable and valid. Your customers are to understand the nature, purpose, and consequences of the collection, use, or disclosure of their personal information by your company. So I really should add a caveat to my last comment about not posting information to Facebook about your clients. Only do so if you have their explicit consent. Get an email confirming that you have their permission. Obviously, for marketing purposes, you may want to include a testimonial or pictures, things like that. Before doing that, you want to have explicit consent. Don't assume that because they're your customer and they like the service that you provided that they want to be a subject of your social media post. Get consent. Pursuant to the CPPA, to obtain consent, a business has to provide the individual with the following at or before the time of collection of the personal information. You have to tell the client the purposes for the collection, use, or disclosure of their personal information. You need to explain the manner in which that personal information is to be collected, used, or disclosed. You need to provide any reasonable, foreseeable consequences of the collection, use, or disclosure of their personal information. You need to explain the specific type of personal information that will be collected, used, or disclosed. And you need to provide the names of any third parties or types of third parties to which the organization may disclose their personal information. The consent principle is flexible. So if the personal information that's collected is innocuous and the purpose for its collection is straightforward, you can rely on a form of consent that is more implied. When the information is sensitive, you want to have explicit and documented means of obtaining consent. So if you collect financial information, medical information, anything that would be considered sensitive, you want to have specific consent, documented specific consent for your collection, use, and authorization of that information. An individual is able to withdraw their consent subject to legal or contractual restrictions. An organization shall not, as a condition of the supply of a product or a service, require an individual to consent to the collection, use, or disclosure of information beyond what is required by your organization to fulfill the purpose for which you've collected it. Keep in mind, if a person gives their personal information and consents to its use for one purpose, you do not have license to the free use of that information for other purposes. If you want to use their personal information for a different purpose, you need new consent. The challenge for organizations is developing a consent purpose that's broad enough to capture multiple uses, but also specific enough for the consent to be considered knowledgeable and informed. Blanket consents do not cut it. So I have an example of the importance of consent. In November 2020, the Federal Privacy Commissioner, along with those in British Columbia and Alberta, completed an investigation into Cadillac Fairview, which owns several large shopping malls across the country. Cadillac Fairview gathered digital images of mall patrons through cameras that were installed in the mall directory boards. Software then converted the images into biometrical numerical representations of patrons' faces, which was then used to assess the age and gender of shoppers, as well as mall traffic patterns. Cadillac Fairview collected and stored the numerical representations of over 5 million shoppers. Cadillac Fairview took the position that to the extent it was required to obtain shoppers' consent to collect their digital images of their face, such consent was provided for in its privacy policy. The decals on the doors directed shoppers to a copy of the privacy policy that could be obtained from the guest services office. However, when representatives of the commissioner actually made a request for the document at customer services, the attendant there had no idea what they were talking about. The mention of digital imaging, once they were able to get a copy of the privacy policy, was buried in a 5,000-word document. The commissioners found that this was inadequate, and the meaningful consent of shoppers to collect and use their personal information had not been obtained. An express opt-in consent was required for Cadillac Fairview to collect such sensitive personal information. In that same investigation, the commissioners found that information collected from shoppers' mobile devices, such as MAC addresses, geolocation information, was not personal information, as it did not itself or combined with other information identify the individual. Therefore, consent was not required by Cadillac Fairview to collect that type of information. The PIPEDA states that any collection, use, or disclosure of personal information must only be for purposes that a reasonable person would consider appropriate in the circumstances. There is an express recognition in the legislation that a person's right to privacy is not absolute. This is highlighted by the inclusion of terms like reasonable person, appropriate, and in the circumstances. Many people think that the Charter of Rights and Freedoms protects their privacy. It does not. In Canada, there is not an absolute right to privacy. In determining whether a reasonable person would find an organization's collection, use, and disclosure of information is for an appropriate purpose in the circumstances, the commissioner will consider the following factors. So the first is the degree of sensitivity of the personal information at issue. They'll also consider whether the organization's purpose represents a legitimate need or bona fide business interest. It will consider whether the collection, use, and disclosure would be effective in meeting the organization's need. It considers whether there are less privacy-invasive means of achieving the same ends at a comparable cost and with comparable benefits. And they'll consider whether the loss of privacy to the individual is proportional to the benefits to the organization. The factors are to be applied in a contextual manner, which suggests flexibility and variability in accordance with the circumstances. In 2020, the Federal Privacy Commissioner, along with those of Quebec, Alberta, and British Columbia, investigated Tim Hortons after a news article in the Financial Post revealed that its app was tracking users' location at all times, regardless of whether or not the app was in use. the author of the article discovered his location was tracked in excess of 2,700 times in less than 5 months by the Tim Hortons app. Through a third party, Tim Hortons could collect and process the user's device location as often as every few minutes to infer the location of a user's home and place of work, and when they were traveling, and identify when the user was visiting a Tim Hortons competitor. The purpose identified to users for the collection of this information by the app was for the purposes of delivering targeted advertising and to better promote Tim Hortons coffee and associated products. The commissioners held that a reasonable person would not conclude that Tim Hortons' continual collection of location data for the stated purposes to be appropriate, reasonable, or legitimate in the circumstances as required under PIPEDA. Tim Hortons did not have a legitimate need to collect vast amounts of sensitive location information where it never used that information for its stated purpose, so the digital advertising and promoting its products. The commissioners noted that large volumes of location data can be highly sensitive personal information. Trips to a medical clinic can be indicative of specific medical treatments or illness, while other locations can lead to deductions about a person's religious beliefs, sexual preferences, or social and political affiliations. I do want to note that Tim Hortons was not using the location data it collected in this way. This was just something that was flagged by the privacy commissioners as a concern about how such information could be used. The commissioners commented on the amount of data organizations are collecting and the corresponding loss of privacy to individuals that was created. Proportionality is particularly important for organizations to consider in the context of the digital economy, where largely unlimited tracking can be so easy to implement and deployed for a myriad of highly invasive purposes. By collecting and analyzing the granular location data of customers without regard to proportionality, organizations create the significant risk that personal information is no longer used for appropriate purposes, but is rather amassed and treated as a mere good or commodity to be exploited or as a tool of corporate surveillance. The craziest part of all of this is that Tim Hortons made very limited use of the data that was collected through the app and did not use the data for any targeted advertising, as in 2019, which was the year before the commissioners conducted their investigation. It had shifted internal policies away from using location data. Despite the policy change, it continued to collect vast amounts of user data through the app. As a result of failing to properly monitor its data collection practices, stock prices temporarily fell after the news broke, and a privacy class action was commenced against Tim Hortons. This really highlights the importance of making sure that your privacy officer is involved across all functions of your organization. If the marketing team had told Tim Hortons' privacy officer, no, we're no longer using location data for our marketing purposes, then the privacy officer could have communicated to the IT department and said, hey, we no longer need to collect all of this location data through the app. Please disable that feature. And Tim Hortons would have likely not been subject to a class action or had this scathing investigation report from the privacy commissioners published. The business has to protect personal information in a way that is appropriate to how sensitive it is. The more sensitive, the more strong the protection that will be required. A business needs to institute security safeguards that will protect personal information against loss or theft, as well as unauthorized access, disclosure, copying, use, or modification. PIPEDA does not specifically set out any particular security measures that must be used by a business. As technologies evolve and new risks emerge, new security safeguards may need to be implemented. Safeguards include physical measures, such as locked filing cabinets, restricting access to different places in your office, installing alarm systems. Up-to-date technological tools include the use of passwords, encryption, firewalls, security patches, and then organizational controls include things like security clearances, limiting access to personal information on a needs-to-know basis, staff training, and agreements with your third-party vendors. You should consider the following factors when selecting the right safeguards to put in place. The first and really the most important, the sensitivity of the information and the risk of harm to an individual if it was exposed inadvertently. Obviously, health and financial information are highly sensitive and require strong safeguards. The amount of information that you collect from your clients. If you collect vast amounts of information, you want to make sure that you have strong security safeguards in place. The extent of the distribution to others of the personal information, the format of the information, is it electronic or is it paper, the type of storage of the information, and the types and levels of potential risk that your organization faces. One of the best safeguarding practices an organization can have is not to collect or retain more personal information than is necessary. So make sure you have a retention schedule in place. I've worked with some clients that have kept all of the personal information of their clients since the day they opened their door for business. There's no need to retain that amount of information. If you haven't dealt with a customer or client in 10 years, why do you have their personal information? If there's a data breach, there's just that much more information that could be exposed. So you really expand your risk when there's exposure by retaining unnecessary personal information of clients. Data breaches are on the rise. I'm sure nobody's surprised to hear that. In a recent survey conducted by TELUS and IDC, 75% of Canadian organizations reported experiencing a data breach at least once. 60% of small businesses and 54% of medium-sized businesses had a breach in the last 3 years. The Canadian Centre for Cybersecurity reported that in 2022, of businesses that fell victim to ransomware, 18% were in the manufacturing sector, 14% were in the business and financial services sector, and the third hardest hit sector was retail, which accounted for 8% of those hit. So many people would think, manufacturing, they don't deal with a lot of personal information. They were the #1 hit in industry sector in 2022. The fact that a data breach occurs does not automatically mean that the organization failed to meet its safeguarding obligation. Rather, compliance will turn on whether the security safeguards in place at the time of the incident were reasonable and appropriate in the circumstances. Most data breaches, as I've noted, are a result of human error, falling victim to phishing schemes, sending personal information to the wrong recipient, and of course, there are hackers that work to take advantage of vulnerabilities in your data management systems. PIPEDA defines a data breach as the loss of unauthorized access to or unauthorized disclosure of personal information, resulting from a breach of an organization's security safeguards or from failing to have any safeguards in place. As I've noted, you want to have a breach response plan in place. If there is a breach incident, you do not want to be caught flat-footed in responding to it. The TELUS survey showed that 20% of survey respondents did not have a response plan at all. If there is a data breach, there are steps that your business needs to take. Immediately contain the breach and designate an appropriate individual to lead the initial investigation. That individual should have appropriate scope within the organization to conduct the initial investigation and make initial recommendations. If necessary, a more detailed investigation may subsequently be required. You also need to be turning your mind to your reporting requirements, both internally and externally. PIPEDA requires a business to report a breach of personal information to the Privacy Commissioner that poses a real risk of significant harm to individuals. Those affected individuals also need to be notified of these breaches if the real risk of significant harm test is met. The real risk of significant harm is determined through an assessment of the sensitivity of the personal information that's involved, as well as the probability the personal information can be misused. Significant harm includes bodily harm, humiliation, damage to reputation or relationships, loss of employment, business, or professional opportunities, financial loss, identity theft, negative effects on credit records, or damage to or loss of property. Businesses need to report the data breach as soon as is feasible after discovering it. Businesses are required to keep records of all privacy breaches, whether or not they have to be reported or not. Under PIPEDA, it's an offense to knowingly contravene PIPEDA's reporting, notification, and record-keeping requirements relating to breaches of security safeguards, and doing so could lead to fines. If somebody on your team sends personal information to the wrong person via email, that's a data breach. That needs to be recorded. It doesn't need to be reported depending on the sensitivity of the information, although you would need to do an assessment as to whether it does need to be reported. But even if it doesn't, even if the personal information is not that sensitive, you need to record it that there was that breach. Customers understand when a business falls victim to a threat actor. What your customer is going to be critical of is how you handle the breach incident. Your goal should be to exceed the expectations of your customers in responding to the breach. Use your response as an opportunity to increase your customers' trust in your brand. 79% of respondents in the telesurvey said it was necessary or very important to offer restoration services to affected individuals. This means providing identity theft reimbursement coverage, credit card and bank monitoring, and restoration support, such as having someone available to advise on how to get their identity back if it was stolen. Once the immediate steps are taken to mitigate the risk associated with the breach and to report it if necessary, you need to invest appropriate resources to investigate the cause of the breach and consider whether to develop a prevention plan. The level of effort should reflect the significance of the breach and whether it was a systemic breach or an isolated instance. This plan may include a review of the physical and technical security safeguards of your organization. You can either conduct that internally or have a third party perform the audit. You want to review your policies and procedures and any changes that might be needed to reflect the lessons that you've learned from that breach. You want to review your employee training practices and offer refresher training if necessary. And you also want to review your agreements with your service providers, as well as any kind of retailers that you work with, and the data security safeguards that they have in place. As noted previously, the federal government introduced Bill C-27, the Digital Charter Implementation Act, which if passed would enact the Consumer Privacy Protection Act, a new privacy legislation for private sector organizations currently governed by PIPEDA. This proposed legislation sets out much more clearly the privacy and information security obligations that Canadian businesses must meet, but also increases the control and transparency for consumers when their personal information is handled by an organization. So the key highlights of the proposed Consumer Privacy Protection Act include the transfer of information to service providers. You can transfer clients' personal information to a service provider without their knowledge and consent. However, you have to ensure that the service provider has substantially the same protections of personal information as the organization. There's also exceptions in the legislation to when you need to collect a person's consent to collect, use, or disclose their personal information. The Act allows an organization to collect or use an individual's personal information without their knowledge or consent if made for a business activity that's listed in the CPPA, and if a reasonable person would expect the collection or use for the activity, and it's not for the purpose of influencing the individual's behavior or decisions. So there's several criteria that need to be met before you can rely on one of the exceptions to consent in the CPPA. The CPPA also includes a right to be forgotten. Many people think wrongly that they can write to a company and say, I want you to delete all of my personal information. Many companies will delete your information. It's good practice in terms of relationships with your customers. However, they're not actually required to do that pursuant to any legislation in Canada. An individual under the CPPA, once passed, may request in writing that organization dispose of their personal information that it has collected. With limited exception, the organization is to just dispose of the information as soon as feasible. The CPPA also provides for algorithmic transparency. So if your company uses algorithms or artificial intelligence on request, you must explain how a prediction, recommendation, or decision about an individual was made and how the information was obtained. So currently, some companies are using AI in recruitment or their hiring decisions in terms of culling the resumes that they receive when they get large amounts of them. Relying on artificial intelligence in this manner could potentially be challenged on an inherent bias in the algorithm used, depending on the types of candidates that are being called out of the or called out by the algorithm. With artificial intelligence and algorithms, a common saying is garbage in equals garbage out. It's the success of an algorithm is really dependent on the type of information that it's learning from. The CPPA also provides for the de-identification of personal information and restrictions related to that. Measures used to de-identify information must be proportionate to the purpose for which the information is de-identified and the sensitivity of the information. There's a prohibition on the use of de-identified personal information to identify an individual with limited exceptions. The Act also provides expanded powers to the Privacy Commissioner. Currently under PIPEDA, the Commissioner really doesn't have any teeth in terms of enforcement. Under the CPPA, it would have the power to make orders regarding compliance with the Act. It would also have the power to recommend that a penalty be imposed by the newly created Information and Data Protection Tribunal if certain provisions of the Act were contravened. The CPPA also provides for a new right of action. So a cause of action will exist for individuals who are affected by an act or omission by an organization that has been found to be in contravention of the CPPA for damages for loss or injury that they've suffered as a result of that contravention. Another act that will come into effect when Bill C-27 is passed is the Personal Information and Data Protection Tribunal Act. The tribunal will have jurisdiction over all appeals regarding the Privacy Commissioner's decisions. Importantly, at least 3 members of the tribunal must have experience in the field of information and privacy law. So at least decisions that are being made by the tribunal will have experts on the subject matter coming to those decisions. The tribunal will have all the powers, rights, and privileges that are vested in a superior court with respect to evidence and the enforcement of its decisions, and the tribunal will have the power to award costs against parties. And a third act that will come into force with Bill C-27 passage is the Artificial Intelligence and Data Act. The stated purpose of ADA is to regulate international and interprovincial trade and commerce in artificial intelligence systems by establishing common requirements applicable across Canada for the design, development, and use of those systems, and to prohibit certain conduct in relation to artificial intelligence systems that could result in serious harm to individuals or harm to their interests. ADA defines harm to mean physical or psychological harm to an individual, damage to an individual's property, or economic loss to an individual. A business that carries out a regulated activity with anonymized data will have to establish measures with respect to the manner in which that data is anonymized and how it will be used and managed. ADA has been criticized as lacking teeth, as most of the substantive law is to be prescribed by regulations that haven't yet been released. I don't hold myself out to be a tech expert, but with what I do know of artificial intelligence, trying to regulate it is going to be complex and complicated. Bill C-27 is currently at second reading in the House of Commons. It was last discussed in March 2023. There's no reason to think that the Act won't be passed, provided that the Liberals and the NDP maintain their coalition for the foreseeable future. And quite frankly, it needs to be passed. Canada's privacy legislation is very outdated. We're falling behind other countries in the world in terms of our data protection legislation. We really need to be bringing ourselves in line with other countries. When passed, there will be a transition period to allow businesses to bring themselves into compliance. So you will have time to adjust your practices to comply, but it doesn't hurt to start turning your mind to these issues already. The important takeaway for business leaders is that data protection is at the forefront of government regulation, and there are significant consequences for those businesses that choose to ignore their data protection obligations. So I want to talk about the electronic monitoring policy. This was a policy that is now required due to the Ontario provincial government introducing legislation that required certain employers to have an electronic monitoring policy in place. So who has to have this policy? And that's every employer in Ontario with 25 or more employees. They have to have this policy with respect to electronic monitoring of employees. Independent contractors do not fall within the definition of an employee in the Employment Standards Act. So if your business operates solely with independent contractors, then you would be exempt from having to have this policy. The electronic monitoring policy was to be in place starting on October 11, 2022. On January 1 of each year, an employer will have to determine whether it has 25 employees, and if it has reached that employment level, it will be required to implement an electronic monitoring policy by March 1st of that year. The policy must contain whether the employer electronically monitors employees, and if so, a description of how and in what circumstances the employer may electronically monitor employees, and the purposes for which information obtained through electronic monitoring may be used by the employer. Note the use of the word may in this requirement. You'll need to include purposes that are secondary to the use of electronic monitoring. What jumps out to me is when a company may want to use data from a technology in an investigation into employee conduct. If there's a chance that a type of technology or software will be used for that purpose, then it needs to be included in the policy. The policy also has to set out the date that it was prepared and the date that any changes are made to it. You'll need to review that policy regularly, obviously annually, when you are having to make any revisions to it based on the number of your workforce, to ensure that new technologies that have been onboarded by the company are captured in the policy, and any new requirements prescribed in the regulations have been adopted into the policy. One of the curiosities of the Working for Workers Act, which introduced this policy requirement, is that it did not include a definition of electronic monitoring. And the Privacy Commissioner has also not provided any guidance on what constitutes electronic monitoring. The Act does not provide any kind of criteria for or limitations on the collection, use, and disclosure of personal information of employees. So really all it does is say you have to let the employees know that you are collecting that information. It doesn't say, but you can't collect certain types. It's silent to that. It's literally just making you be transparent with your employees in terms of the type of information you're collecting and why you're collecting it. Be mindful, however, that there may be limits to monitoring or the use of information collected through monitoring software that's contained in employment contracts or collective agreements. In the government's announcement of electronic monitoring policy, it made specific reference to employers being transparent on how employees use company computers, cell phones, GPS, and other electronic devices. Many of you may be thinking that we don't use bossware or productivity tracking software, so we don't need to worry about an electronic monitoring policy. Or that position assumes a very narrow definition of electronic monitoring. Every business likely has at least one form of software that it can use to monitor whether or not an employee is working. Most just aren't using it for that purpose. But the legislation isn't limited to monitoring for the purpose of employee management or discipline. Remember that the legislation states that your electronic policy needs to include a description of how and in what circumstances the employer may electronically monitor employees, and the purposes for which information obtained may be used by the employer. The legislation does not distinguish between monitoring via software installed on a device, such as a workstation or a handheld, or on a network. Employers should list applications regardless of where they're installed. Most employers collect and use a wide range of data for network security purposes. Many companies would not be able to attract new clients or conduct business without this network security software in place. Many RFP require candidates to disclose data protection practices, including providing information about network security. As well, if you want to have cyber incident coverage for your insurance company, the policy will likely require your business to implement data protection software. This software, in order to provide notification of threats to the networks, reviews pretty much all actions being taken on the network. So in drafting your electronic monitoring policy, you'll want to consult with your IT department to understand what network security software is in place and the information that it's collecting. You will want to use that information to monitor employees if you ever had a breach incident that was the result of a rogue employee. You're going to want to be able to access that information to find out exactly who it was and how it was done, and likely to take disciplinary action or termination. So if you have network security software in place, it would need to be listed because there's a chance that you may have to use it one day to monitor your employees. Does your company have GPS in its fleets? There is considerable data collected in the navigation systems in vehicles. Do your employees have to docket their time in order to calculate the amount to charge to the client for the service provided? That software would be captured by the legislation as electronic monitoring. Does your company have access cards to enter into the office or facility? You can use that information to monitor when your employees are coming and going. Has your HR department ever used that information to manage a performance issue with a habitually late employee? Your policy needs to account for the various purposes and circumstances for which the information collected through electronic monitoring is used. That can include safety, security, attendance, timekeeping, performance management, training, and discipline. With the amount of data that's collected by employers, most businesses will fall under the electronic monitoring requirements and will be required to have a policy in place. Okay, so we are nearing the end, and I want to make sure that I leave you with some practical tips given all the information that I've given you today. The first and really the most important is that you need to get consent. There's really no way around it. It has to be meaningful and informed. Tim Hortons tried to obtain consent for the collection of user location data. However, it did not explain to the user that it would collect that location data when the app was closed, which would result in extensive data collection. The commissioners actually found that Tim Hortons attempted to obtain consent by providing false or misleading information by indicating that the user information would only be collected while the app was in use. It also failed to clearly communicate the consequences of consenting to the collection of the location data. Without sufficient details for the users to understand the substantial consequences of granting the Tim Hortons app permission to access their location information, the consent collected could not have been meaningful. The author of that Financial Post story actually had his location tracked while he was in North Africa, as well as in the Netherlands, even though Tim Hortons does not operate there. My next tip is to sit down with your insurance broker and ensure that you have coverage for data breaches. Hackers are not stupid. Many now are searching your system once they get access to it for your insurance policy to find out what the policy limit is, and then that's what they're going to set as their ransom demand. Even if you do not deal with a lot of personal information, you still need cyber incident coverage. I worked with a manufacturing client whose email system was hacked. The hacker sent an email to a customer who had received a large invoice. We're talking six-figure invoice. The client got the email saying, can you please transfer payment for this invoice to our new bank account that we've just opened up. The customer, not knowing that this was a hacker, did so, paid that large invoice, not to my client. My client then is like, oh, this invoice is outstanding, reaches out, hey, we're just following up on payment. And that's when the breach is learned of, and that the hacker now has that money. The customer who paid the invoice said, you know what, we've got our cyber incident coverage, we'll pay you that invoice again because we'll get reimbursed from our insurance company. So my client is now made whole. Problem though is that their customer's insurance company took an off coverage position. I don't know why they took an off coverage position, but they did. So now my client is left in a situation where their customer is now out double what the invoice total was for as a result of a breach that happened at my client's company. So, you know, do you say, oh, so sorry, so, you know, you're out, bad hacker? Obviously, your customer is not going to be all that excited about that approach. Do you take the hit and return the money, and now you are out all of that money for the work that you've performed? My client did not have a cyber incident policy, and perhaps if they had, they could have turned to their insurer and said, this breach has occurred. We're now out 6 figures because this invoice was paid to an incorrect party. Please provide us coverage. So even if you don't think that you're at risk, you could be. Your insurance policy is going to set out requirements that you're expected to meet in safeguarding your data, conducting training for your staff. Make sure that you are complying with these data protection requirements in the policy. Ask yourself right now, if you have cyber incident coverage, do you even know what the data protection requirements are? If you've answered no, you could be handing an insurance company a very easy reason to take an off-coverage position if you had to make a claim. And that claim is going to be for one of your most important assets, your data. So make sure that you look at your insurance policies, know what data protection requirements you have to have in place, and get them in place. A privacy impact assessment can be conducted by your privacy officer, or you can hire an external advisor to perform them. The CPPA does not have an explicit requirement to conduct privacy impact assessments, but it does require that you record all the purposes for which you're going to be collecting customer information. That is a component of a privacy impact assessment. So obviously you'd be meeting that legislative requirement if you perform the privacy impact assessment. As well, it's going to help in terms of being able to prove your due diligence if there ever was an investigation or a complaint brought against you. Contractual safeguards. You've heard me talk about data protection agreements. You want to make sure that they include terms about who's going to be responsible for controlling the data, collecting the information, retaining the information, how it's going to be protected, and hopefully some inspection rights to make sure that the third party is complying with the safeguards that they say they have in place. You cannot escape your statutory obligations by subcontracting to third parties. Do not blindly contract with service providers to process your client's data without first doing some due diligence and putting some protections in place as assurance that the service provider will in fact protect your client's data. And it's not necessarily just your client's data, it could be your proprietary data as well. Data breach reporting. If you are a victim of a data breach, 2 of the first people to contact, your insurance company and your lawyer. Many cyber incident policies, in addition to providing coverage, will also provide you with access to a data breach coach, public relations specialist, tech support, and consulting with your lawyer can assist in navigating the response in a manner that will be of benefit if litigation were to be commenced in response to a breach, like that Tim Hortons class action. That concludes my presentation today. And on that happy note, we can move into the question period. For those of you that aren't currently receiving the Learner's Business Law newsletter, and you would like to do so, you can go to privacyondemand.ca and subscribe there. Dylan will put a link to that web address in the question answer list so that you can sign up for it. I also just wanted to let you know about a service that I offer called Privacy on Demand, where I essentially act as your privacy officer when you don't have one on staff. There are block rates available based on the number of hours that you want to have available to you. And more information on that service is found on privacyondemand.ca as well. Please feel free to reach out to me. You might be like, oh gosh, I need to go and take a look at this or that policy. And if you do find that you have a question after today's presentation, please feel free to reach out to me, and I'd be happy to answer any questions that you have offline as well. If there's no questions, then I will say thank you once again for attending, and I hope that you all have a great day. Thanks so much.